Hello and welcome to Competology Academy, and today we are going to discuss our next part of Santhal Pargana Tenancy Act, and that will be chapter 4 and 5. And if you want to go through the videos of the acts and the sections and the chapters of the Santhal Pargana Tenancy Act which were discussed earlier, that is up to chapter 3, then you can go to the playlist of the Santhal Pargana Tenancy Act 1949 and the Jharkhand land related laws. So from there you can get the rest of the videos, and the upcoming videos will also be added to the same playlist, right? So here let us start with the Santhal Pargana Tenancy Act chapter 4. And before I go onwards, I would like to request you all to please subscribe the channel and press the bell icon to get notified whenever we upload new videos. So here the chapter 4 is related to the settlement of the wastelands or the vacant holdings, and this is up to section 42. From section 27 to section 42 delineates in what manner any of the wasteland or the vacant land which is not being cultivated by any person or any rayat in the Santhal Pargana region. So how does that could be brought under cultivation, and the land ownership could be acquired in what manner, what are the terms and conditions, and from where to get those pattas or the settlement authorities, right? So here section 27 says that the settlement of the wasteland shall be made by the pattas or the amalnamas in the prescribed form. So through the notification, the government will prescribe a format of form in which the pattas or the amalnamas will be provided to any rayat or any person in Santhal Pargana to get the ownership rights or cultivation rights of any of the wasteland or the vacant land. And 4 copies of the pattas or the amalnamas shall be prepared. 4 copies shall be prepared, and these 4 copies, one each copy will be given to the rayat. First copy will be given to the rayat to whom the land is being allocated. One copy will go to the deputy commissioner, one to the landlord, and one to the village headman or the mool rayat, whatever be the case, right? So this is to inform all the people, all the related authorities, as well as the rayat who is getting the wasteland, that this land is now not vacant land or the wasteland, but the ownership of this land or the cultivation rights of this land is being given to a particular rayat, right? Now section 28 says that in making the settlement of the wasteland or the vacant holding, in addition to the principles recorded in the record of rights, so in the record of rights some of the principles are mentioned already, that how does the vacant land can be used, to whom it can be allocated, or to whom, with whom it can be settled. So these will be there in the record of rights, as well as some of the other terms and conditions are mentioned in the act itself. And what are the terms and conditions that should be considered while settling any of the vacant land or the wasteland are? So here the first is fair and equitable distribution of the land according to the requirements of each rayat and his capacity to reclaim and cultivate it. So every person is having some kind of limitation, whether he is a farmer or whatever it is. So the farmers also have the limitation to cultivate any land with their own resources, whatever the ox or the plug, whatever the cattle they have, using that they can cultivate a particular amount of land. So while resettling or settling the vacant land or the wasteland, it should be kept in mind that equitable distribution, first of all equitable distribution, which means that the land should be distributed in such a way that the land, all of the land or majority of the land should not get concentrated in few hands, right? So first thing is that. Thereafter, the requirement of the rayat. So whichever rayat is in requirement of more land, that if a rayat is having too less land to ensure his proper livelihood, then that rayat should be preferred first, as well as capacity to reclaim the land and bring it under cultivation. So this principle should also be followed over there, right? Now, any special claim for the services rendered to the village community, society, or the state should also be considered. So what does this special services, any claim to the special services? So what kind of special services means here? That whether this land is required for that of grazing land, for the samsan ghat or such kind of burial land or the cremation land. So all these kind of special services, Jahir Than or the place of worship, these should be considered first. So if there is requirement of land for such special purposes, then that wasteland should be allocated for these purposes, or vacant land should be allocated for these purposes, rather than it is being allocated to any rayat for cultivation purpose, right? Next is contiguity or the proximity of the wasteland to the jamabandi land of the rayat should also be considered. So it should be a principle that those rayats should be preferred first to settle any of the vacant land or the wasteland whose land is in the vicinity of the vacant land. So suppose that here it is a vacant land, right? And any of the Rayat is having his land here. So this Rayat will be preferred first for the settlement of this vacant land, rather than being considered a Rayat whose land is located in the far-flung areas than that of the vacant land or the wasteland, right? So this will again be a principle which should be considered while settling any of the wasteland or the vacant land, right? Now, the provision for the landless laborers who are bona fide permanent resident of the village and are recorded as having their dwelling houses in the village should be preferred. So those rayats, basically they are not rayat, but they are the resident of that village who don't own any piece of land, but they are landless laborers. They are landless people who are working in the fields of the other people. So these rayats, these landless laborers who are the bona fide resident of that village should be considered first, because for their livelihood they have to work in the fields of other people, right? Next is section 29. It says that a Mool Rayat or a village Pradhan shall not settle any wasteland or vacant holding by himself without the permission of the DC. So before settling any of the vacant land or the wasteland, the permission of the DC is necessary. Without his permission, no wasteland or vacant land can be settled with anybody. Section 30 says that no vacant holding shall be subdivided for the purpose of settlement without the consent of landlord and approval of the DC. So suppose that here is a piece of vacant holding or the wasteland, and if it has to be settled with any of the rayat, but he is saying that the whole complete plot I am unable to cultivate, so give me half of that plot. But this cannot be done without the permission of the landlord and the approval of the DC. So if it has to be decided and with is to be settled with two different rayats, then the prior permission of the landlord and the DC is necessary, right? So section 30 says that. Section 31 says, except as otherwise provided in this act, where there are two or more village headmen or co-mool rayat or landlords in a village held jointly by them, and the settlement of the wasteland has not been made jointly by all such village headmen, co-mool rayat or the landlords, as the case may be, the settlement may on objection be set aside or modified at the discretion of the deputy commissioner. So suppose that if there is a village and in that village there are two landlords, two jamindars are owning that jamindari rights of that village collectively, or two mulrayats or two village headmen. So the consent of both of the village headman or mulrayat or the landlord is necessary to settle any wasteland. And if it is not done with the consent of both of them, then in such case what will happen? In such case, one of the person who is not have given the consent for the settlement of the land can go on to complain to the DC, can go on to file an application to the DC that my consent was not with this settlement, but unilaterally he has, the another jamindar or the landlord or the mulrayat or the village headman has done this settlement of the land without my consent. So in such case, the DC will hear the case and appropriately whatever he thinks rightful, he will modify the settlement or he may set aside the settlement altogether, right? Next is section 32. It says that if a person is aggrieved by the village headman, Mool Raiyat or the landlord, as the case may be, in settling or refusing to settle the wasteland or a vacant holding, or if aggrieved by any other person in respect of such land or holding, he or she may file an application to the DC within 1 year of the date on which the reclamation in pursuance of the settlement was commenced or settlement was refused. So here section 32 says that if somebody is aggrieved with the village headman, that I had said him that this vacant land or the wasteland should be settled with me and I am going to cultivate that land, I am willing to do that, but the village headman or Mool Raiyat or the landlord refuses to do that and he leaves the wasteland as it is. Or in case if the village headman, Mool Raiyat or the landlord does the favoritism, like he settles such kind of vacant land or the wasteland to his near and dear ones, to his known persons, then in such case what will happen? The aggrieved person can go on to file a complaint to the DC office within 1 year from the date on which such kind of event had occurred, like the settlement was refused or favoritism was done on the process, in the process of settling the land. So in such cases the aggrieved person can go straight away to file a complaint to the DC, right? And section 33 says that in the event of any settled land not being brought under cultivation within a period of 5 years from the date of settlement, the DC shall have the right on an application made by a Jamabandi Rayyat, the village headman or Mool Rayyat or landlord, as the case may be, to set aside the settlement and make the fresh resettlement as per the full law in force. So suppose that some of the person has taken the land under the settlement system, that land was vacant earlier and now at present time that land is settled with him, but he is not cultivating that land, and suppose that he had received that land in 2018 under the settlement system, that land was vacant land or the wasteland, he received the land and he should have cultivated that land, but by 2023 he have not started the cultivation of the land, then in such cases already 5 years have lapsed from 2018 to 2023, then in such a case this settlement will be pronounced null and void, it will be set aside, and the DC has the power to make fresh settlement as per the rules of this act or as per the local customary rules of Santhal Pargana, right? So this is again a section 33. Next is section 34. Here it says that suitable portion of the village wasteland may be settled for the purpose of being used as the Jahir Than, burning and burial ground in consultation with the Gram Pradhan, right? So the Gram Pradhan, Mool Raiyat or the DC will allocate some part of the vacant land or the wasteland if it is necessary that that land should be allocated for the purpose of Jahir Than, that is the place of worship, religious place. Next for burning, that is the Samsan Ghat, in the term what we use, Samsan Ghat, burning or the cremation ground. Or in some of the tribals, as we have already seen in the customs and culture of the tribals, that some of the tribals used to do the burial as the last rite. So for that matter also they need the land. So in case the burial ground is not sufficient in the village, then that vacant land or the wasteland can be settled as the burial ground or any other purpose which is necessary in consultation with the Gram Pradhan, Mool Raiyat or the DC. So again this is a provision here to settle the wasteland or the vacant land. Next, section 35 says that the settlement of any wasteland for the purpose of irrigation, drinking water, protection from the flood shall not be done without the approvals from the Rayyats and the Gram Pradhan or the Mool Rayyat or the landlord or the commissioner, DC, right? So all these people should give the consent so that some of the land which is wasteland or the vacant land can be allocated for the purpose of irrigational work, right? Like the construction of canal, construction of ponds or ahars, whatever it is. Drinking water purpose, the same thing, that is the ahar or the well, whatever it is, or the protection from the flood, like construction of embankment or the other things, so that the flood water does not enter the cultivated land. So all these things can be done, and the settlement of the wasteland and the vacant land can be done for this purpose, but there should be the prior permission of the Gram Pradhan, Mool Rayyat, landlord, and the DC. So here these three are basically the common people, and one of them will only be there in the village, that will exist, like that of the Gram Pradhan or Mool Rayyat or the landlord, and above all them the main authority is the DC. Wherever you will find that the permission is needed for doing something under the SPT Act or even the CNT Act, then the DC will be the supreme authority within the district who will make all the decisions related to land, right? Next, no charges shall be levied for the use of such places for irrigation, bathing, washing, or drinking purpose. So, like under section 35, whatever the land that has been allocated for the community use, like that the common people can use, because it has been allocated by the government for the purpose of drinking water, for the purpose of irrigation, or any other purpose. So the complete village population can use that facility without any charges, because it is for the common purpose, common use, right? Now, the next section is section 36. Here it says that the rivulets or the drains on the boundaries of the village, burning and burial grounds, camping grounds, land bearing the boundary marks, village paths, and the other places of worship shall not be converted to any other purpose by any Rayyat. Such lands shall not be settled also with any of the Rayyat. So here what happens, many of the Rayyats are like some greedy people, right? They go on to encroach on the land that is allocated for the canals, or the land that is allocated for the purpose of pond, or the burial ground, or the burning ground, or the worship place, or even those of that the path, the common use path. So if somebody goes on to encroach that, then that can also be pronounced illegal, and such land that is allocated for the purpose of these common use cannot be resettled with anybody, right? So here it is a restriction. Section 36 is a restriction on the settlement of various lands which are allocated for special purpose and specific purpose, right? Next, section 37, it says that all the Rayyats of the village shall have the right to graze their own cattle within the village on the recorded grazing land, on grazing land set apart by the deputy commissioner under section 38, and on the village wasteland which is excluded from the village under the Santhal Pargana settlement regulation and reserved to the promote the growth of the forest under section 34. So here this section says that if the villagers want to graze their cattle, graze their livestock, then whatever land on which there is no ownership lies with any of the Rayyat, that is the wasteland, that is the vacant land, or those lands which are specifically allocated for the purpose of grazing land under section 38, as well as for those lands which are left behind for the growth of the forest. In those lands, the villagers can graze their livestock and cattle without payment of any charges. And here section 38 itself says that no land recorded as the village grazing land or gochar. Gochar means that same where you can graze your cattle, right? shall be utilized by anyone for any other purpose than grazing. So here it is a restriction that none of the Rayyat can go on to cultivate the gochar or the grazing land, right? So no encroachment can be done on that. Here it is a limitation. And if the area recorded as grazing land or gochar in less than 5% of the total area of the village, the DC may, in consultation with the landlord, village headman, or the Rayyat, set apart a suitable area of the village wasteland for grazing purpose. So here it says that if the total allocated land for the purpose of gochar is less than 5%, then the wasteland or the vacant land can be allocated as the gochar land or the grazing land by the DC in consultation with the landlord, Mul Rayyat, or the village headman, whatever the case may be. So here one question arises that according to the Agriculture Survey or the Forest Survey of India, what is the total amount of land that is classified as the grazing land throughout India? As if we consider the whole geographical area of India, then what is the percentage of total land of India that is classified as grazing land? It is a very important question. UPSC goes on to ask such kind of questions, right? Next, section 39, it says that the Rayyats may, with the permission of the landlord, excavate on the land other than their holding tanks and other reservoirs required for drinking and other purposes, and may harvest the fish and other produce of the same according to the arrangement made with the landlord. So if a Rayyat, if a person wants to excavate any water body, any pond or some kind of thing, so that he can utilize the water that will be collected in that water body for the purpose of irrigation and for other purposes like bathing, drinking, etc., as well as for harvesting and cultivating the fish rearing, then he can make an agreement, he can make an arrangement with the landlord, and after that he can do so, right? And such permission shall not be refused by the landlord without sufficient reason, and on such refusal the DC may, on the application of the Rayyat, pass a ruling in this respect. So such permission cannot be denied by the landlord, and if the landlord goes on to deny such kind of permission, then in such case what will happen? The aggrieved person can go on to file an application to the DC, and if the DC finds that there was no sufficient reason behind such denial, then he can pass a ruling accordingly, whatever he fits necessary, right? Next is section 40. Here it says that the landlord or the Mool Rayyat or the Gram Pradhan shall not make any changes in the rights acquired by a Rayyat for fishing in any specific tank or any rights of irrigation. So if already the rights of irrigation and other things has been allocated to a Mool Rayyat or a landlord, then the landlord cannot change it in any way if the right was acquired by the Rayyat for fishing and use of a specific tank for the fishing and other things, right? So here, if the right has already been allocated, then under no circumstances, if there is no sufficient reasonable cause, he can change it by his own order or by his whims and fancies, right? Section 40 says that no vacant holding or wasteland in a Pahadiya village shall be settled with a person who is not a Pahadiya village, and the Pahadiya village is the one that is recorded as such by the commissioner. So in a village which is a Pahadiya village, the lands, vacant lands or the wasteland can be settled only with the Pahadiya people and none other than that. And the Pahadiya villages are those villages which are recorded in the records of the DC office as the Pahadiya village, right? Next, section 42, it says that the DC may at any time, either on his own motion or on an application made to him, pass an order under the provisions of this act for eviction of any person who has encroached upon an agricultural land. So if a person has encroached upon any agricultural land, and that encroachment was illegal, like he has constructed some kind of building or some any other thing, then if the aggrieved person files an application to the DC that such kind of encroachment has occurred on my land, then in such case the DC may evict that person on his own motion, right, or on the application. So this power of eviction lies with the DC. Landlord cannot do that. So keep it in mind, the power to evict any of the rayat from, even if he has encroached some land or from his own holding, lies only with the DC. The DC can order such kind of eviction. And here this is the information for you all people, that our books for UPSC English medium as well as Hindi medium have already been published, and you can get these books from our website, our app, or even from Amazon, as well as the bookshops. Local bookshops can also give you these books. If you want these books one by one, then go to the local bookshops. If you want the whole study material complete kit, then go on to place the order on our website, on our app, or you can contact us directly. Here we are providing huge discount of up to 40 to 45% on different platforms. So if you want these books, then you can go on to order these books directly or from the Amazon, or you can go on to purchase it from the bookshops. The same collection of the study material kit is available for JPSC exam also, in both Hindi and English. Right, now come back to the Santhal Pargana Tenancy Act, that is chapter 5. So here chapter 5 is from section 43 to 52, and it says about the rent that is payable by any rayat, right, for his holding. So here section 43 subsection amendment A, right, so this was added through amendment because here it was needed, because before this the rent was payable in kind also, but later on it was made available that they can pay it in the cash only, right. So the rent in kind shall neither be accepted nor be acknowledged. It is under section 43 because it was amended. Earlier it was allowed to pay the rent in kind also, right. And this amendment was introduced by the Act of 1955, Amendment Act. As per the new regulation, the rent in cash shall be payable in 4 installments. Before this, it was payable in kind also, but after it was made that the rent will be paid only in cash, then it was allowed to pay the rent as 4 installments every year, quarterly installments. In 4 installments, the rent can be paid on the last day of each quarter of a year, and the rent not paid by the due date shall be treated as the arrear, right. So it will be treated as an arrear or the due payment, right. Next, section 44, it says that when the interest of a landlord or a mool rayyat is transferred, no rayyat, village headman or the mool rayyat, as the case may be, shall be liable for the rent that becomes due after the transfer and is paid in good faith to the landlord or the mool rayyat whose interest was so transferred, unless the transferee has before the payment served the notice of the transfer on the rayyat, village headman or the mool rayyat, right. So here it says that if the authority to collect the rent, that is those rayyats, that is the mool rayyat or the landlord whose interest was transferred, right. So now the older rayyat or the mool rayyat or the landlord is not the lawful collector of the rent, land revenue, and if no rayyat or village headman, as the case may be, shall be liable to pay the rent for such, right. So such landlord or such mool rayyat should not be paid the rent, and the new mool rayyat or new village headman will be the person to whom the rent should be paid, and if it is paid in good faith to the landlord or the mool rayyat whose interest was so transferred, unless the transferee has before payment made such notice, then it should be acknowledged, right. Now section 45, it says that a rayyat may make the payment of the rent for any of his holding by sending the same through the postal money order in the prescribed form. So earlier it was possible to pay the land rent through postal money orders. Also prescribed format was available in the that of post offices. So from there you can get the form and you will just fill up the form. You can fill up the amount, you can fill up the address to whom you are going to pay the rent, and you can send the money order. Just the receipt of that money order in the prescribed format was enough to prove that you have already paid the rent by the due date, right? Section 46, it says that the village headman, Mool Rayyat, or the landlord shall keep the records of the rents of all the Rayyats. It is the duty of the village headman, Mool Rayyat, or the landlord, who is the authority to collect the land rent, to keep all the records of the land rent or the revenue that has been paid to him. खतियान में जाके आप अगर अभी आप लोग जाएं वेबसाइट पे Jharnet ke, and if you go on to fill up the details of your land, then you will get the complete details of your land revenue that you have already paid, right? So these kind of records should be kept by the village headman, Mool Rayyat, or the landlord, as the case may be. Section 47 says that every Rayyat shall have the right to receive a receipt for the rent or the interest on the rent paid by him. So you will get a receiving that you have paid the rent. That is a kind of acknowledgement. And right at the time of making the payment, you will have to ask that give me the receipt. उसी समय तुरंत मांग लेना है, right? From the landlord or his agent, if the landlord has appointed any agent for the collection, because landlord is not going to sit and collect all the rent and issue the receipts. He will definitely have some kind of staff that will be considered as a agent of that landlord or the village headman or the Mool Rayyat. So he is liable to give you the receiving of the rent that you have paid at his office, right? Next, section 48, it says that the state government shall arrange to prepare the performa receipt with details of the relevant records and the counter files for use under the above section, and to store the same in all the subdivisional offices for sale to the village headman, Mool Rayyat, and the landlord. So the performa, the receipt, printed form, these will be provided by the state government. This will be developed by the state government, and thereafter it will be stored with the subdivisional officers or the local offices, from where the village headman, landlord, or the Mool Rayyat, as the case may be, can purchase these receipts, and they will go on to issue the receipts after receiving the land rent. Section 49, it says that where a Rayyat holding is transferable, the rent of the holding shall be first charged on the holding, and in the case of the village headman or the Mool Rayyat, the village rent shall be first charged on the holding of the village headman or the Mool Rayyat, placed as the security for the payment of such rent. So if the land is transferable, the Rayyat holding is transferable, then in such case, first of all, if the Rayyat is available over there, then the liability to pay the rent is of that Rayyat. And if in case he is not available, then as a security, the Mool Rayyat or the village headman, as the case may be, will have to pay the rent for that particular piece of land in which the Rayyat is not available, right? Now, section 50 says that here it is easily means that in no case the government is going to make a loss with respect to revenue, whether it is a land revenue. And at that very time, it was a big deal for the government. Nowadays, it is a frivolous thing, because nowadays, what kind of land revenue the government is getting? It has not been increased since independence, right? So here, relaxations in the rent in special cases, in under certain circumstances, the relaxation in the rent can be given to the Rayyats. And what are the circumstances? That is delineated over here. So notwithstanding anything contrary contained in any law or anything having the force of law in the Santhal Parganas, the DC may, if specially authorized by the state government on that behalf, can reduce by order in writing the rent of the holding of the recorded Rayyat in any area or village of any class of land belonging to such raiyat. So here it is clear that the DC can reduce the rent, but for that matter, he should be authorized to do so first by the state government under special circumstances. Then only he can reduce the land revenue. Second point is that he can reduce the revenue, land revenue, that is the rent that is charged on the rayats, but not for a particular rayat, but for a complete village or any particular area in which the holding is located, or any class of land belonging to such kind of rayats. So not a particular rayat will get the relief, but the whole community that has been affected by certain circumstances will get the relief in case of the rent payment, right? So here, which has been settled by the settlement officer under the provisions of the Santhal Pargana settlement regulation. So wherever the settlement has been done by the settlement officer in the Santhal Pargana region, in that case also the land rent can be reduced within the Santhal Pargana region, and for that matter the acts, the sections of this act is sufficient, right? And which is entered in the rent roll or any one or more of the following grounds. So the provisions for the reduction of rent has been mentioned in the record roll, that is record of rights. Then that can be used by the DC to reduce the rent or the following grounds under which the rent can be reduced. So first ground is that permanent deposition of sand or submersion under the water of a portion or the whole of such holding. So if any of the rayat loses his cultivable land and it is unable to, he is unable to cultivate that land because of permanent deposition of sand, that is that land is unfit for cultivation due to the deposition of sand, balu pura jama ho gaya us land pe, so now it has become unproductive. So for that matter his land revenue, land rent can be reduced. Or if his land has got submerged underwater, it is flooded, then in such case also his land rent can be reduced. The landlord of such holding or area has failed despite due notification to make arrangement for irrigation within the period of 6 months from the date of service of notice. So if any of the landlord had been served with a notice by the DC that in these regions of your authority where you are authorized to collect the land rent is facing a condition of drought and you have to make the alternative arrangements for the irrigation in these regions so that the cultivation can be carried out, and if he fails to do that, then in such cases the rent of those lands can be reduced. They, if the landlord had not made the provisions for the irrigation within 6 months of such notification, or he had received the notice from the DC, after that within 6 months he have not provided the irrigation facilities, then the rent of those regions can be reduced. Sudden fall in the average local prices of the staple food crop, determination in the prices should be for a period of 7 years. So suppose that there was a time before 7 years, 7 years earlier, that the rice was being sold at 30 rupees per kg, but after that suddenly in the next year the price reduced to 15 rupees per kg, and it had continued for continuously 7 years that the prices were low, even it fluctuated for 2 to 3 rupees, but it is nowhere near 30 rupees. Then in such cases what will happen, the average income, the overall annual income of the rayats will reduce, and in such cases what will happen, they will be unable to pay the land revenue that was applicable when the price was at 30 rupees. So in such cases again, if the average price, local price of the staple food has dropped and the cultivation was being done for the staple food itself, so For that matter, the determination in the price should be for a period of 7 years. If for 7 consecutive years the price is less in comparison with the earlier price, then the relaxation in the rent can be provided. But here again, the rent will be reduced in proportion to that of the reduction in price. Here what happens? The price has reduced by 50%. So the land revenue, the land rent that will be relaxed will again be reduced by 50%, right? So this is again a provision. Next here, section 51. It says that where the rent has been reduced under section 50, no further reduction of the rent shall be granted on the same ground until a fresh record of rights is prepared under the SPT Settlement Regulation Act. So here what happens? If suppose that there was a flood and for that matter the rent on the land was reduced, so again if the next year faces the same kind of calamity, same kind of flood like situation, then the riots cannot go on to ask the DC that again reduce our rent because this year again the flood has occurred. So on the same ground the rent cannot be reduced for the time period up to which the new record of rights has been compiled and new settlement rent has been revised. So this will be the case. Section 52 says that a landlord or his agent shall be punished if he recovers from a rayyat, village headman or mul rayyat under the landlord anything in excess of the rent payable. So suppose that a rayyat was liable to pay a rent of 50 rupees, but the landlord or his agent recovers from that rayyat around 60 rupees, then in such cases they will be punishable, right? So it is a punishable offense and they can be punished with the fine of 500 rupees or with imprisonment, or both can be applied on that. So if you have watched this video till the end, then please consider subscribing the channel and press the bell icon to get notified whenever we come live or whenever we upload new videos. We bring regularly such kind of informative videos. Those are beneficial for the preparation of Jharkhand Civil Services exam as well as Union Public Service Commission Civil Services exam. And here you can also follow us for regular updates on our Facebook and Instagram handle. You can also download our Google Play app, that is the Competology app, that is available on the Google Play Store. You can find the link in the description box below. All the study materials and those things, the test series, the current affairs magazines in both the languages, Hindi and English, etc., those are available on our app, are also available on our website also. So here you will find these resources very beneficial for you. Here we finish off. Get back to our channel for the next discussion on the Santhal Pargana Tenancy Act. That will be for the next chapters, that is chapter 6 and 7. Here we finish off. Thank you very much and have a nice day.